Hi, I'm Denice Gierach of the Gierach Law Firm. We have an outsourced general counsel program for many of our manufacturing clients. And as part of that, we like to give a lot of education to our clients and to a wider audience of manufacturing people. And so I like to bring in experts in different areas that can speak to issues that you may have in your business and you may need the answers to. So today I brought Todd Parkhurst, who is an intellectual property attorney in Chicago with Partridge Partners. So welcome, Todd.
Thank you.
Thanks for coming.
Thanks for having me.
So today I wanted to go through issues in the intellectual property area so that the listeners could learn what the trends are and what's going on in those areas and avoid having problems later, because we really want to be more preventative in nature rather than reactive in nature when there's a problem.
Good.
So I know the audience, many of them know what these different concepts are, but just to bring everybody up to speed, what are the different types of intellectual property?
Sure. There are, in the law business, there are four intellectual property domains, as they're called. They include trade secrets and patents and copyrights and trademarks. And I know most people listening to this have some idea what those are, but as we go through them, I'm going to try to provide a more precise definition of each of those concepts and those legal areas here.
Okay, so when you look at how can a business owner and operator legally protect their intellectual property these days?
Well, one way is to protect it by not blabbing it, not disclosing it. One of these areas is the area of trade secrets. Mm-hmm. Every manufacturer almost certainly has some kind of trade secrets. It can be the method of making the product. It can be what's in the product itself. Mm-hmm. It can be the market they sell to and how they go about addressing that market, something like that. Trade secrets are business-related information which you know, mm-hmm. and so far as you know, nobody else knows, and it gives you an advantage in the marketplace for that kind of thing. Now, how do you protect your trade secrets? The answer to that is you protect it by not blabbing it, by keeping it a secret some way. Here's an example of that goes way, way back in time, but it's still relevant today. Back in 1886, there was a Mr. John Pemberton who was a doctor in Atlanta, Georgia, down there, and he treated more or less family people at the time, and he treated a number of little old ladies there in Atlanta, Georgia, who constantly complained about having the ague. Now, it's not clear to me what the ague was, but they just felt bad and they didn't like that. So he developed some medicine for that, and it included a lot of different materials. We'll come back to that in just a minute, but he'd give this to them and it kind of pepped them up and they felt better, and so he thought that was great stuff, and so he called it CocaCola. Now, if you think about the front word for that, yes sir, yes ma'am, it may be that there was some cocaine in it, but that didn't come up at the time. Everybody felt good about it, and so he developed the formula for making Coca-Cola. And he needed to protect it as a trade secret. He didn't want to patent it because that disclosed it, so he wanted to keep it a secret as best he could. So the way he did that, first of all, was he wanted to be sure the product was coming out the same way every time he made it. So he wrote down the formula for it. It included 27 different ingredients at the time. And then he wrote those down and he put them in a safe, and that safe is still in the Coca-Cola headquarters in Atlanta, Georgia today. And yes, they've come up with new Coke and other different variations on it, but those formulas are all written down. But no one person ever has access to all of those ingredients and all of those methods of production. For example, Mr. Jones, you know that part of the formula for Coca-Cola, the classic Coke, is parts 1 through 17. Mr. Smith, you know 18, 19, and 22. Mr. Green, you know 21 and 20. and like that. And then you put those things together, and you put them all together, and you take them down to the bottling company. You don't tell anybody what's in it. There, they mix it all together, and off they go. So no one person has that whole formula. That's been true since the start of Coca-Cola Company. You can do that, of course, with anything that's going to give you an advantage. Just don't disclose it. The other way to exploit that, as you probably know, is to license that out. License out formulas for a product. License out methods of manufacturing that you've discovered and work on. And you can license those out. And the license ought to be an NDA, a non-disclosure agreement, so that what you know and what now your licensee knows, he's not going to disclose to somebody else. And so non-disclosure agreements are important things, and they have to be properly constructed. And so that's the reason you ought to hire an attorney who's familiar with non-disclosure agreements and with trade secrets and the methods of keeping those things secret.
Many times I see that manufacturing clients are not as exacting in keeping things secure. And I find that because of that, even though they are considering things as trade secrets, they're not really upheld that way in the courts. Do you see this?
That's right. If this thing gets blabbed out there, or quite independently, if somebody else independently develops it without knowing, for example, what the formula for Coca-Cola is, they just work away on it and they develop a formula that they like, and it's pretty simple, and it's if you were to really analyze it, and somebody who really knew everything about both products would know that they are identical. That's too bad. Too bad. The second developer who developed it independently can do that, and there's nothing the first guy can do about it.
So when we're looking at trade secrets, let's look at something like customer lists, because that's something that's so
right.
basic, and most people, most of my clients would look at that as saying that customer list is a trade secret. So is it a trade secret, and how, since they're using that customer list with sales reps and what have you, how do they really maintain the secrecy of it?
Well, they need to have non-disclosure agreements, and they need to educate and be sure that the customer reps are following the rules about that they're not disclosing this to anybody. But you're right, the customer list will not only have the names and addresses and phone numbers and email addresses of people, but it knows what they like and the kind of products they really want and why they like them that way. And they want to know more than that. They want to know, this guy really is a Chicago Cubs baseball fan, and so I should take him to Cubs games and stuff like that. And they need to keep that information secret if they can, to the best of their abilities.
So when you were talking about non-disclosure agreements just there, you were really looking at, we have to make sure that those salespeople that are going to see this information are covered themselves with a non-disclosure agreement, that they'll only use it for the purpose that they're given it, which is really to make sales.
That's right.
And anything that they add to it becomes part of that trade secret.
That's
so
right.
that it is protected as well.
That's right. As those customer reps learn information about the clients, they need to give that back to the company, because that's who they're working for, and they need then to protect that. And there's a lot of cases in which sales representative A sees customer B, and he discovers that customer C really wants a product which does D, or something like that. And maybe there's some discussion about that within the company, maybe not. And finally, sales representative A says, you know what, I've had it. I'm going off on my own, and I'm going back to see those clients with the information that I developed. Well, if the customer non-disclosure agreement is written properly, they will know that they can't use that information which they themselves developed, because they developed on behalf of their company, their employer at the time. And this causes much gnashing of teeth and grumbling and litigation over that kind of thing. And it's expensive litigation. Like anything in litigation, you can't guarantee the outcome.
True.
And so best you have a good non-disclosure agreement in there, and check to be sure that your customer reps and your other employees are following that as you go along.
Well, let's talk about licensing. There's a big concern now that manufacturers are manufacturing part of the product abroad, And so if they license out some of their trade secret information to a company abroad, what protections do they really have, even if they have a license agreement?
Well, the license agreement ought to say that the law of the United States will apply, but it's also going to be true, inevitably, that the law of the other countries will apply. And so, for example, in China, as you have seen in the newspapers and in the trade journals, that gets to be a problem. All you can do is get the best agreements you can with people. You may want to consider other forms of intellectual property protection for it, such as patents or copyrights, but it may be an uphill battle. That's the best you can do with it. You need to get a lawyer to help you look at that stuff, and if you're going to, for example, manufacture the thing in China, you need that lawyer to contact lawyers in China who specialize in intellectual property protection in China and work with them to be sure that the agreements cover not only matters from the U.S. law standpoint, but from the Chinese law standpoint as best you can.
Yeah, I've seen, particularly with China, the concern is that China won't honor the agreement even if it looks and should be ironclad. So many of my clients look at doing the part that's really more trade secret-ish production in a place that they can control, and then shipping product for assembly or whatever to China or other places in Asia where it would be honored. Do you see that as a trend too?
Yes, I do. That's a good strategy, and I would advocate that. And it also permits you, the trade secret owner and the manufacturer here, to control a little bit better. If these guys are in China are not honoring the agreements, it's a little easier that way to cut off doing business with them, cut off trade with them, and find somebody else in China who will help do that.
So even within licensing agreements, you can limit the scope of what you're licensing.
Yes.
So you don't have to license this much. You can license this much for a particular product or whatever.
That's right. And you can license it out to do certain steps of the manufacturing process or certain steps of the sales project. And that then gets to the questions of the cost-benefit ratio. Is it going to cost a lot of money? Can I get somebody else to do it cheaper? Can I get somebody else to do it? So, as I say, you need lawyers' help and advice, not only from the U.S. standpoint, but you need from the Chinese standpoint or from other countries. There's great competition now between China, Vietnam, and other countries in Southeast Asia, in Hong Kong, about kind of doing that stuff. And many lawyers in those countries specialize in U.S. Hong Kong, U.S. China, U.S. Vietnam relationships and business relationships. So they are familiar, certainly, with U.S. law and the interrelationships with that law with their own native law.
So this is really important to get the right people working with you, since like licensing is such a specialized thing. It's not a document you can buy online and really have it suited for your needs. It's really more something that if you have a particular product, this is where your future is going in your manufacturing business, then you really have to protect it the best you can.
That's right.
So don't scrimp on hiring the right people that are going to protect your assets. This is a big thing, and most people try to circumvent it or close their eyes to whether or not it's going to be protected. So let's move on to like patents. Tell me more about the patent area and what the trends are.
Sure. The patents are in some ways kind of the reverse of trade secrets. To get a patent, you need to apply for a patent. In trade secrets, you already have the trade secrets, strictly speaking, theoretically speaking, and all you're doing is protecting your existing assets, although they may be not concrete. They're intellectual assets, so you can protect those with agreements to do what you need to do. The patent is something that gets created. The patent are granted, not registered, but granted by the U.S. government and other countries, and they will give you the right to keep others from making, using, selling, or offering for sale what is the subject of that patent in those countries. So, for example, the assets can be patents that cover business assets of prime importance, and they ought to be prepared and prosecuted and filed by a patent attorney. Some people try to draft their own patent applications, and I've seen that, and it is trouble every time. You need to get a patent attorney. The patent attorney needs to draft the patent application. It will include drawings, specially made. It will include a description of the product in such full, clear, and exact terms as to enable, I said enable, one skilled in the art to make and use the same. That's the patent law. It's a direct quote, and that's been the law since 1797 with just some minor changes. Other countries have similar laws. And then you file that patent application, and then what happens? Nothing for months while the patent application works its way up through the list. They try to work on the oldest patent application first, the examiners, and then the examiner will look at that patent application, and then we'll see if it really does define something new and useful. And by new, the law means that it's never before in the entire history of the world and mankind ever been made or thought of before. So that means that somebody has to run a prior art search for prior patents and prior developments. That means these days looking through 10 million US patents, I said all over the world, so now they've got to work through the 80 million patents that have been issued in Europe and the millions of patents that are issued in China and elsewhere. Well, that's a theoretical deal. So they're running word searches, but there are companies that specialize in running those searches, and they will work with the patent attorneys to see what exactly the inventor has developed. The inventor thinks he developed the whole thing. I got all 5 steps. Well, there's steps 1, 2, and 5 already disclosed in this prior art. So maybe 4 in combination with the others is novel, and that's what's going to be the patent.
So now with a patent, as you mentioned, you're fully disclosing what is going into either the process or into the product itself. So I see some of my clients deciding not to do the patent and instead to keep it as a trade secret.
Sure.
Because when you have a patent itself and somebody wants to copy it, all they have to do is change certain things of it and then they can get their own patent, right?
Well, they may or may not be able to get their own patent, but having their own patent doesn't necessarily mean that they don't infringe the first guy's patent.
Okay.
I have a patent application here for parts of an automobile transmission, and it's got 5 parts. And the patent covers a thing that's got the transmission that's got parts A, B, C, D, and E. Somebody else comes along and wants to do that same thing, but he adds part F. That's not going to avoid the patent. So the objective of the patent attorney when he's soliciting that patent is to get the broadest patent he can. And the rule of thumb is that the claims are the things that define what he can then keep others from making, using, selling, or offering for sale. So again, the next rule of thumb is that the shorter the fewer the words in the claims, the broader that patent is going to be. One of the most broad patents is one word. It's, and I'm going to pronounce it wrong a little bit, phenometalline. What is that? It's made by a little outfit down in St. Louis called Monsanto, and it's Roundup.
Oh.
And Roundup, again, I'm going to overstate it some, but to give you the idea, the Roundup will kill weeds. It kills weeds that have broad leaves. It doesn't kill leaves that have narrow leaves. Consequently, it's great for rice fields and rice paddies. It kills the broadleaf weeds, and it doesn't kill the narrow leaf rice. So that's part of the work of the strategies of the efforts of the patent attorneys to do that kind of thing. So the broader the patent, the more you can protect it. If you have a patent like Roundup, that can keep somebody else from making something that's got 1% Roundup in it. It can keep them from making Roundup that gets added later sometimes. If it's more broad, if it's more narrow than that, then maybe you can't protect it all that well.
So like patents can be licensed as well.
Oh, absolutely,
right?
absolutely, absolutely. And that's a great way, frankly, to work this thing. You license this thing out to other people so they can exploit part of the market that you don't have the resources or the particular interest maybe in developing now. And when you do that, you get paid a royalty, or you get paid something else. Maybe you work some deal, get a cross license from something that they're making. But let's assume a simple situation in which you license somebody out, and they're going to pay you a royalty, and that royalty is going to be a percentage of the revenue that they gain, the gross revenue that they gain from selling that licensed product. This is an interesting business then. This becomes an easy job. It is quintessential then. It comes out this way. You come to work on Tuesday morning. You don't have to come in on Monday. You come in on Tuesday morning, just about this time. Well, a little after 12:20 here. And you open the mail from over the weekend and on Monday, and you take out the checks, the royalty checks. Then you get in your car and drive down to the local bank and you deposit the checks. You're through for the week. It's time for golf.
There you go. Well, I do see a lot of my clients who do have patents do strategic partnerships with other people so that they can do that.
Sure.
Everybody wants that wonderful life. Sure. Collect your money and go play golf.
It may be that you can have an opportunity to exploit some technology that somebody else has developed and has a patent on, and so there may be some cross licenses here to enable both companies to maximally exploit those markets. That's quite possible.
Yeah, so that's an interesting way to, you don't have to use the patents yourself in order to develop the product and sell the product.
Oh, right.
So,
right.
Consider that. But again, those strategic alliance agreements really have to have the right wording in there to protect you and limit the scope of whatever it is that you are allowing them to use that patent for.
That's right.
Let's move on to like copyrights. Because I'm imagining a lot of my manufacturing clients have, or have used materials that are copyrighted.
Sure. Copyrights arise in, very broadly speaking, art stuff. Copyrights arise in music, in writings, pictures, images, movies, videos, animations, even three-dimensional objects such as statutes and the like. Copyrights arise when you create the work. Copyrights, for example, in writings arise the minute the print hits the paper or hits the video so they can be produced some way. And copyrights must be, because they arise right when they're created, they can be registered. I didn't say you have to apply for a copyright. The copyright arises when you generate the product. But you can register those existing rights with the U.S. Copyright Office. Now, you don't have to do that if you don't want to, but if somebody copies what you're doing, then you can't sue them until you have registered the copyright. So it's worthwhile to keep in mind, as with patents, file the patent application early as best you can. Get your patent attorney to file it. Once you've got your invention completed, you think, or a version of it completed. In copyrights, register that copyright as soon as you can once you have your image, your music, or whatever it is written and worked. It doesn't protect everything in copyrights, that's for sure. It protects the creative part, and it will not protect against, for example, somebody doing a parody of what you did before. Roy Acuff and his friend Mr. Rose wrote a song called Pretty Woman, and I'm a terrible singer, so I'm not going to try to sing Pretty Woman walking down the street. And there was a rock group, kind of a grunge group, called Two Live Crew, who then made a parody of that called Big Hairy Woman, and their song was Big Hairy Woman. And so, it's not really my taste, but that's all right. And that case went all the way to the Supreme Court. The Acuff Rose people asserted that that Big Hairy Woman song was a copy in general parts, important parts, of the song. Well, the Supreme Court agreed, but said that's a parody and that constitutes free speech. So you don't always win those things. But better you have the pistol cocked and loaded, ready to go. Better you register those copyrights ahead of time so that when the problem comes up, not if and when the problem comes up, you're ready to go. And you don't have to wait for the several months it takes to get the copyright registration to go through the Copyright Office.
So in the context of like a manufacturing client, where do you see the best things that they're not copywriting now, but they should be?
The videos of what they're doing.
So like materials written about their product that they do?
Right. The copyright does not extend to covering the method. If you have a method of manufacturing, for example, you can attempt to register the copyrights. It may be rejected on the grounds that it is simply descriptive of a way to make something. But you can file that application. You can see what the Copyright Office says about that. They may reject the copyright. You may want to argue with them about it a little bit. But you certainly can't get a copyright registration unless you apply for it. Right.
So in the case of like you have a website and you have materials on the website, can some of that be copyrighted?
Yes, certainly. Certainly the pictures, the images, and the arrangement of the website can be copyrighted, yes.
Okay, because I do see some people doing it, but a lot of people not. So is there any
the downside to trying it is simply the cost, and the cost for copyright registrations is relatively less expensive than, for example, patent applications.
Right. Now, just as we talked about with patents and trade secrets, you can also license copyright materials, right?
Yes, absolutely.
Okay, so that's an area that if you do have a copyright now and you are interested in having other people use that and promote you either with in a strategic alliance of some sort, that's something that you should do. Another way of licensing that you need a professional who knows how to draft those things to limit the scope of what you're allowing them to do with it to something that's going to make you money and them money too, but not so that they steal your ideas that are contained in there.
That's right. You are generating we are generating right here copyrightable subject matter in this video.
Right.
You can register that, and if somebody tries to rip it off and copy it verbatim, word for word, with the pictures and all that, we can probably get an injunction against that.
Okay. So all of these concepts, you have to be ready to enforce, actions against people that are trying to steal your intellectual property, right?
Right.
Okay, so there's a cost to doing it, but if you don't, there's a cost to not doing it too. So how about in the area of trademarks? This is, something that, like you have a product name or something that is particular to what you are doing in your business, that you probably see this even more.
Sure. Trademark rights, again, arise from use of a trademark with the product or service that you're offering. Trademark rights can be a word, symbol, or device that is used in connection with the goods or services in commerce. And they can be registered because they already exist when you started using them that way. Those trademark rights can be registered through the U.S. Patent and Trademark Office. And that will then give you the right to bring a lawsuit, if you need to, in the federal court system in order to enforce those trademark rights. What's an infringement? It's using a term that's deceptively similar to the registered trademark or the trademark rights. Now, trademark rights arise just from use, I said. It didn't say anything originally about registration. So you can bring a lawsuit for an unregistered trademark infringement, but those are 40 miles of uphill and rocky road, and they're very expensive, and they run into a lot of trouble. If you have the imprimatur of the U.S. Trademark and Copyright Office and Patent and Trademark Office on your trademark, then that's got a lot more psychological clout for that. The trademark rights will then protect you from somebody using a deceptively term, not just in the little market that you're in, but throughout the United States, at least in theory. And it should work that way. There's some stories about that, but that's the way that works.
So when you look at like trademarks, would words like Coca-Cola, would
Okay.
that be something that would be subject to a trademark?
Absolutely, it was, and it is, and the trademark rights
Okay.
are still in force. Those registered. The first trademark registered was for the depiction of the picture Samson registered wrestling with a lion, and that's been on continuous registration since May 27, 1884.
Wow, that's an old one.
The terms Coca-Cola and Coke have been registered, and they've been in use for well over 100 years as well. The other slogans that they have, things go better with Coke, have been registered. The script, that flowing script of Coca-Cola, has been registered, and it's now being used and registered for stuff that's far beyond just a beverage. As you probably know, they're used for clothing as well.
Right. Taglines, that comes to mind for me. So like you have Nike, just do it.
Yep.
That is also, part of a trademark,
Yes,
isn't
yes.
it?
And their little swoosh smile at the bottom can be registered. It probably is. I'm sure it is.
Mm-hmm.
And I'm sure Just Do It has been registered.
Mm-hmm. So, and if we bring this back, because, those are all like really large companies. If we go back to, a manufacturing client, they all have names for processes, so those could all be trademarked. They may have taglines, and that could be trademarked. So many people have not, taken care of this and should.
Right. There are two parts to this. There's kind of the yin and the yang to this in some senses. First, if you're going to use a trademark, use a new phrase, a new slogan for something, you ought to run a search to be sure that nobody else has already registered that.
True.
Don't just start using it, There's nothing worse than having some guy in Punxsutawney, Oklahoma, saying that he has a federal registration on the very slogan you have been using here for some time. And there's a little story about that. Down in central Illinois, there's a little town called Charleston, Illinois. And in that town, there was a guy who ran a restaurant for years and years and years down there. And he and his wife decided they were tired of cooking the same stuff all the time. And so they retired, but they wanted to still be in the restaurant business, but they didn't want to mess around with all the fancy 5-course dinners and stuff they'd been doing for a long time. So they decided they would set up a restaurant that sold hamburgers. And so he was thinking, the guy's name was Elmer Hoots, H-O-O-T-S. So Elmer thought of a new word. He's going to call it Burger King. And he set it up and started running it there. He didn't check to see if somebody else is using it. It turns out that some business jaspers down in Florida had been running Burger King restaurants, and it was an early franchise, and they'd been putting out Burger King restaurants all over the country. And they started out putting them out in Miami, and as they got busier and better and more successful, they started expanding geographically, and they came into Charleston, Illinois, and set up a Burger King restaurant there, or were going to set it up, and what? Here is Elmer Hoots with a Burger King restaurant. Well, he wasn't licensed to do that, so they sued him for trademark infringement. Mr. Hoots had been using the trademark long before the guys in Miami started using Burger King. So now the issue became a federal court issue, and it went up before a judge over there, and it looked like both sides had good cases to win. Mr. Hoots had been using it long before, and the rights arose at the time his first use started. So his first use was superior to the Miami guys, but they had a federal registration. So it went before a court, and the judge is a famous guy here in Chicago who was a good friend of ours. And the judge is a pretty wise guy, and he brought both sides in. So they had their arguments with the lawyers in the courthouse and in the courtroom. And he said to them, all right, come in here. We're going in here in my chambers. We're going in here in my office. Sit down. All right. Tell you what, give me a quarter. Got a quarter? Give me the quarter. He slaps it on the map, and he centers the quarter on the map of Charleston, Illinois. So the quarter isn't all that big, but it takes in some area. And he says, here's the ruling. You, Mr. Hoots, you can use it because you have superior rights because of your earliest use. You can use it only within the area I've got marked here on the line covered by the quarter. Got it? Nowhere else. Mr. Hoots says, that's happy. I just want this one little restaurant. That's fine. All right. You guys can do it whatever you want. You can set up other franchises and restaurants anywhere you want outside the area marked by this quarter. Got it? Well, that's okay. That's what we want to do. Fine. Okay. End the case. Next case.
Well, that judge was a real Solomon.
That's right.
One area I see people get clipped on is they use clip art, talking about clipped, to put into their, brochures or into, their website or whatever. And sometimes where they've gotten this from, unknowingly, it's owned by someone else.
Right.
But they're not charging a fee, so they assume everything on the internet is free.
Right.
And all of a sudden, they get this demand from a law firm, demanding that they stop using it and giving them a bill for $5 or $10 grand. Have you seen this a lot in your practice?
False, 1,000 times false. Clip art is not
free.
Clip art is copyrightable material, and the copyright can be registered. And if the copyright is registered, then the person who went to the trouble of working up that clip art and the trouble of registering the copyright is highly likely to have a loaded pistol, which he may aim and shoot at you if you do that. So again, it's helpful to search that stuff to see if it's copyrightable, and if it's got a name on it there, you might even want to go so far as to write the guy a letter, the company a letter, and say, hey, creative artists, I see you got this nice little thing here. We'd like to use that in part of our advertising. May we do so? The worst that can happen is they say no. It cost you what to find that out? The cost of doing the letter and the cost of talking to the guy maybe on the phone a little bit, which is way less than it's going to be to have a lawsuit land on your doorstep just as you're getting that product off the ground and really rolling.
Right, I do see that's something that clients come to me all the time with. That they end up getting the letter, the cease and desist letter, demanding money, and they were totally unawares.
Sure.
Because people do assume everything on the internet is free. I don't know why they do, but they do.
Well, but keep in mind that there's a trade-off here. You see a piece of art there that looks really neat, and you'd like to use that. And so, well, all right, maybe I take the advice and check and see if I can use it or pay a license fee or what. And so you try to check, and well, the company is not clearly identified on there, the owner, and so you got to look around for that. And then you're more struck, and it turns out no, the guy's brother-in-law really was. So it may turn out to be a pain in the butt, and you may have to decide, well, I'm not going to run the risk. I'll try another piece of art. I'll try something else, some other kind of clip art. Or you may just say, you know what, the exposure here is not going to be too big after talking to Denice about it. Maybe I'll just try to use it and see what happens. It's a business decision that you kind of got to make all the time.
Right. So we've talked about a lot of different topics. So what questions have I not asked that you would like to elicit information to our audience?
Well, I think we've covered a lot of them in some little detail. So the general takeaway I would urge, is that you talk to an experienced intellectual property lawyer about what you're trying to do here, and see what kind of intellectual property rights you may be able to create, or maybe already have created. And then you ought to consider carefully registering those rights, registering your patent, applying for and getting a patent granted, which is not theoretically the same as a registration of existing rights. Registering your copyrights, registering your trademarks, and don't blab out your trade secrets.
Well, that's a really good summary. And Todd, I really appreciate you coming and talking with this audience. I think they all have learned a lot about how to protect themselves with intellectual property. So thank you so much.
Thank you for having me.
And thanks to our audience again for listening to this interview, because I really want everyone who listens to it to learn a lot that is going to impact their business in a positive way. So thanks for listening, and I look forward to seeing you on the next video.